Buenas tardes a todos y bienvenidos a la Universidad Francisco Marroquín en una de las charlas organizadas con el Instituto Juan de Mariana. Estamos hoy presentando a una persona que la verdad es que tiene un currículum impresionante y que casi lo he tenido que ordenar un poco por saber por dónde empiezo, pero yo creo que lo que más le define a él, lo más importante para él, es que es emprendedor, sobre todo. Es alguien, como él dice, soy un serial entrepreneur, un emprendedor en serie. Durante toda su vida ha estado continuamente involucrado en muchos proyectos y, de hecho, actualmente pues dirige, pues, lo que es lógico, es un angel investor, es el propietario de una compañía que se dedica a apoyar a los emprendedores, y no solamente lo hace desde esa compañía, sino que también lo hace pues como profesor, enseñando. Y de hecho, bueno, pues su obra seguramente de la que se siente más orgulloso es este libro, Unless Your Inner Company, que es un libro increíble, buenísimo, y que de hecho, bueno, pues se le ha tenido la amabilidad estos días de estar con nuestros alumnos hablando de ese libro. Aparte de ello, creo que hay que hacer también mención a que, bueno, él es ingeniero del MIT, no solo es ingeniero del MIT, además ha sido presidente de alumno del MIT y pertenece al board de trustees de dicha universidad. Es MBA por Harvard también. Y bueno, seguramente es una persona de renacimiento, ha tocado todos los temas. Pues yo tenía aquí una pequeña lista de sus temas que está últimamente tocando. Emprendimiento, por supuesto, muy preocupado por todo el tema regulatorio en el emprendimiento. La educación es uno de sus puntos más importantes. De hecho, él, digamos que es el gran defensor de la libertad de expresión en el MIT. Y bueno, pues es algo que es muy importante en la Universidad Americana, que haya gente como él. Y de hecho, pues también otro tema importante es que él fundamentalmente es libertario. Él está muy comprometido con todo el movimiento libertario. Es alguien que se prestan siempre muy amablemente para ir a cualquier foro, poder hablar de la libertad, del emprendimiento, de la regulación. Y bueno, pues también es un gran amigo de la Universidad Francisco Marroquín, y siempre que le pedimos por favor que venga, pues aquí está. Y sin nada más, pues adelante. Y thank you, John, for coming to Madrid. And please.
My pleasure. Thank you so much for having me, Arturo. Thank you for that. It is a thrill to be with Instituto Juan de Mariana. I have known about you for many years through my friend Gabriel Calzada at UFM and Gonzalo Melian at OMA, which is, of course, a joint venture between UFM and IJM. So it's a thrill to be here. Thanks so much. Our topic today is common law and its essential role for well-designed or well-informed legislation. But common law is disappearing. What to do? Well, let's find out. Here is my thesis for this talk. Common law and civil law are analogous, respectively, to exploration, that is discovery and learning, and exploitation, that is standardization and scaling, in the widely used exploration, exploitation, optimization model used throughout the social sciences and elsewhere. And exploration informs exploitation, and similarly, common law informs civil law. And so if common law is disappearing, that's a real concern. So here's our agenda. First, what is common law? Second, what is civil law? Third, what is this exploration, exploitation, optimization model? And fourth, how do common and civil law fit into that model, and what are the implications? Okay. All right. First, common law. Common law, this slide says it traces its history back to the Magna Carta, and indeed it does, but it actually goes back much further than that, because common law is emergent, and it was the first law that ever existed. I just heard David Friedman, the son of Milton Friedman, speak at a conference in Prague this past weekend. One of the things he mentioned was common law property rights, in effect, existed before humans, because animals are territorial. They recognize property and respect others' property and defend their own property. And that is an early form of a right, a primitive form that is wholly emergent. There's no top-down government or democracy or parliament or chief executive who protects that. Well, anyway, so common law traces its history to the Magna Carta indeed, which limited the rights of the crown over barons, initially just over barons. It gave the barons rights. Later, that was extended to commoners. And it provided for such things as private property, no taxation without representation, juries of peers. It's referred to as judge-made law. That is, it's designed to resolve disputes. It's very modest. It doesn't try to set policy. It doesn't try to anticipate every dispute that might arise in the future. It only addresses each dispute as it comes along, and it's consensus-oriented. If the two litigants in litigation agree to a resolution of their litigation that they feel is optimal, it's very unlikely that the judge will overturn that. And so it's a way of discovering what's optimal for different cases. It uses and harks to the reasonable man or reasonable person standard. And by that I mean it asks, what would a reasonable person in this jurisdiction, this society, consider the most reasonable outcome? So it's tied closely to the values, the customs of the society. It's based in reality. It's reinforced by and co-evolves with customs and technologies. It's not codified. That is, it exists in the huge database of decisions of judges and juries, and it evolves as cases are decided. It doesn't provide hard and fast rules, but it provides guidance. As I said, it only addresses cases as they arise, so it's economical. Now, that is common law, and some 60 former British colonies and protectorates around the world have inherited primarily common law traditions, thanks to the Magna Carta. Every country in the world uses a mix of common law and civil law, but the mix is more heavily weighted towards common law for the countries that have, like the ones listed here, that have inherited British common law traditions. Now, in contrast, civil law is imposed from the top down. These are statutes, regulations, executive orders. And these are generally, trace their history back to Napoleonic code in the early 19th century in Europe, but actually it goes back before that to Roman law, which the Napoleonic code tried to bring some order to. And Roman law itself was based on emergent common law originally, so the two strands do have a common parent if you go back far enough. It's just that the common law, the British path, maintained the emergent judge-made law tradition longer and more emphatically than did the European strand. So in the early 19th century, Napoleon, as you know, codified French law, and it helped him consolidate power. Judges couldn't make new law, they could only apply the law. If two litigants had a consensus that they felt was the best solution, the judge could not likely go with that. He had to follow the law, and so it kept the society from finding the best solutions. So it disempowered judges from finding better resolutions. It is indeed the legal regime of choice for politicians worldwide because it gives them control. It's policy implementing rather than dispute resolving, in the words of Damascus. And according to these authors, England had legislation since the Middle Ages, but before the 20th century it was used sparingly and reluctantly. So most of the German power, the European powers and their former colonies have inherited civil law traditionals, and that's continental Europe, Latin America, North Africa, and most of Asia. Now, just to be very clear, in English, civil law has two meanings. It can mean either non-criminal law, in which case it's distinguished from criminal law, or it can mean it can be distinguished from, civil law has two meanings. It can either mean non-criminal law, in which case it's distinguished from criminal law, or it can mean legislation, statutory, administrative law, and regulations, in which case it's distinguished from common law. And of course, it's in this second sense of the word that we're using the phrase civil law. Okay, how do the two types of law evolve? Well, quite differently. Common law continuously, as I mentioned, through real-world cases. There are many decisions made in parallel throughout the land. There's a process of variation and selection that goes on because different courts of law may decide things differently, and they may get escalated to a higher level law, which will select which law becomes the law of the land. I think of it as akin to an anthill. None of the ants design the hill, do they? The ants are all doing their own thing, and this beautiful symmetrical anthill emerges. Very similar, broadly, with common law. It is a structure without design. No one controls what it is, but all these individual decisions made give rise to it. As a result, it's less predictable short-term and more predictable long-term. It doesn't make huge leaps from year to year as civil law can. If the legislation decides on a major legislature decides on a major new piece of legislation like Obamacare or the Sarbanes-Oxley legislation, that can give rise to huge differences in very short term. So common law is less predictable short term, but more predictable long term, in contrast to civil law, which is just the opposite and gives rise to regime uncertainty, since we never know what a dictator or a parliament or a Congress might do. Nassim Taleb, who we all know from The Black Swan, describes common law as organic or anti-fragile. In contrast, civil law is design or imposed. Okay, now civil law has attached to it a whole bunch of problems that don't arise with common law. And I don't want to badmouth civil law here or give you the impression that I think there's no role or place for civil law. There is a role and place for it. It provides consistency, and it's a way of scaling up, providing across a broad geographical area the same laws. But it has some real drawbacks that may limit its usefulness. And we have to be sensitive to those. So these are some of the problems that attach to civil law. Public choice concerns. What do I mean by that? I mean when issues that are unrelated to public welfare influence what the law is. And so there are things like cronyism, hidden taxes that increase the revenues of an agency, the fact that regulatory agencies are risk averse because, let's take the Food and Drug Administration, for example. If there's one drug that leads to someone dying that they approve, that's embarrassing to them. But as long as they don't allow drugs to be approved and used in the first place, that people can't see clearly, how people's lives are being harmed. It's invisible, but it's very visible if they do approve a drug and someone dies from it. So they're naturally risk averse, and that's we see that again and again in, for example, the Federal Aviation Administration having such strict regulations for drones. There are unintended consequences of civil law. If we make the laws too draconian, black markets can arise. They can lead to unemployment, inadequate housing if it's zoning, unemployment if we set the minimum wage too high, for example. And I talk about how civil law deters entrepreneurship, or can deter entrepreneurship, innovation, and economic growth in this paper which was in the International Journal of Entrepreneurship and Small Business. You can download a copy of it. It's at my website /regulations, so feel free to avail yourself of that. And that paper actually was the precursor of this talk, and much of the content in this talk is in that paper. Now, what's the current status of the two forms of law today? Well, every country, as I said, uses a mix of both. Civil law is more practical and efficient and scalable when cases are numerous and similar. For public goods and commons concerns where property rights are not well defined. It's used when it's more practical or predictable than case-by-case decisions. In many cases, people prefer civil law to common law because there's predictability. If I have a traffic violation, I know what the penalty is going to be. If it were a common law situation, that might not be so predictable. Civil law is often common law codified at a point in time, and that's a good thing because this is a case where the common law has informed the civil law. So, for example, criminal statutes in most of the U.S. states are based on our common law. Now, what are the trends? In the 20th century, the U.S. has shifted from common law to statutes as a primary source of law, and civil law is increasingly supplanting common law everywhere. Let me show you how common law correlates with economic growth. Here, if you look at GDP per capita for North America, which is primarily a common law jurisdiction or geography, its GDP per capita is about 4.4 times GDP per capita for South America, which is primarily civil law in former colonies of Spain and Portugal. And there's one paper says that countries that have inherited British common law traditions have enjoyed 0.5% per year greater growth in GDP per capita over the last two and a half centuries as compared to those that primarily inherited civil law traditions. Well, indeed, if you take slightly more than 0.5% and raise it to the 250th power, you get 4.46, which is approximately the same as this ratio here. So the numbers do work out. And think about it. Today, the primarily common law countries in the world are the United States, Great Britain, Canada, Australia, New Zealand, Singapore, Botswana in Africa. I could go on and on, but these countries generally have enjoyed higher economic growth or growth in GDP per capita than the rest of the world has. Botswana is an interesting case study because it was the fastest growing economy in the world from 1965 to 1995. 7.7% per year. And it inherited, in effect, two forms of common law. One was its original tribal law, and two was British common law when it was a British protectorate after 1885. And Britain governed Botswana very lightly, and so it preserved the tribal law tradition there, but added British common law as a layer on top of it. And that combination worked very well for Botswana. I don't mean to suggest that common law alone is sufficient for economic success, but it is an important driver. These are all a bunch of different former British colonies, so all of them inherited some amount of British common law traditions. And this is their ranking, the World Bank Governance or Rule of Law ranking in 2008. And of course, Singapore does very well, Burma does not so well, and the others are in between. And generally, it's correlated with two factors. One is to what extent has British common law been integrated with the local law, and two is to what extent is there representation of local people in the legislature. This is very consonant with the Acemoglu-Robinson model from Why Nations Fail. Is anyone familiar with that book? I have a feeling this gentleman is. He's nodding his head. And the thesis of that book is that it's inclusive rather than extractive political and economic institutions that have led to nations to be successful. And it's the extractive ones that have failed over the centuries. So this is broadly consonant with that. And so substantial common law helps but isn't sufficient for economic prosperity. Good governance also helps. Big surprise there. And this is the ones that are most successful combine quality of governance with a common law tradition and influence. Okay, now let's take a new area, drones, that are heavily governed, at least in the US, by civil law, and let's think about how it could be governed by common law. Well, today in drones, with drones, there's a panoply of regulations that govern them from the FAA. They can only be used away from airports, only up to 400 feet in altitude, only during daylight. There has to be a dedicated operator. They can only be used for non-commercial purposes. If you want to have a waiver for any of these, you can get them, but then you have to go through a waiver process. You can imagine not just how significantly that discourages use of drones, but it also disincentivizes drones to develop intelligence. So if I have to have a dedicated human operator, what's the point in the drone developing the ability to detect other drones and avoid them? And that's the extrapolation and avoidance. There's no incentive for drones to develop peer-to-peer communications with each other to avoid each other. And indeed, the number 1 supplier worldwide of drones is not in the US at all. It's DJI in China is the number 1 provider of drones worldwide. Now, how could drones be governed instead? Well, for centuries, dangerous animal laws have been on the books. What is a dangerous animal law? It's a law that says if you own a dangerous animal like a tiger or snake or that hurts somebody or whatever, you're responsible for the behavior of that animal. And so the responsibility shifts to you. The same approach could be used with drones. If you own a drone and it does damage, you are responsible. Drones can also carry cameras, of course, and so they can peep into people's windows. Well, for centuries, peeping Tom laws have been on the books. Both of these are common law. It's not okay to peep into somebody's window without them knowing about it. Later, that law was extended to cameras when cameras came along in the 19th century, and later in the 20th century, it was extended to video. Exactly the same could apply to drones. And think about it. When is a peeping Tom a peeping Tom? Obviously, if you go right up to somebody's window and peek into it, that's peeping. But what if you're peeping from, say, several hundred yards away? That's probably okay if you're just looking in that direction. The same kinds of issues and sensitivities are purely, based on the customs and what a reasonable person in the jurisdiction would consider reasonable. So making those decisions could apply very well to drones. And if we did use common law rather than civil law, and with all these constraints, I'm sure, we'd have drones today delivering packages for us, and the technology would be much further ahead. Very much the same for autonomous vehicles as well. And in the paper that I mentioned previously, I talk about both drones and autonomous vehicles. This chart compares common law with 4 types of civil law. And these are its influences, examples, how it evolves, are there public choice concerns, and are there unintended consequences? Well, with common law, you can see it readily evolves. There are no public choice concerns, and unintended consequences tend to be minimal. But all of these apply to the different forms of civil law. But I've identified 4 different types here, the best type and the worst type. The best type are statutes that are informed by common law. And as I said, tort and contract law, and also criminal law, it has generally been codified from a real-world common law experience, the Uniform Commercial Code in the U.S. Now, think about how it evolves. It doesn't evolve smoothly and gradually, as does common law. It requires an amendment, renegotiation, public content, and so forth. And there's a risk of all these public choice concerns. These are relatively not as good as this. So what I'm saying is, even civil law, when it's well informed by common law, has the disadvantage that it doesn't evolve smoothly and it gets fixed at a point in time. An example of that are federal motor vehicle safety standards, which were established 50 years ago. It was informed by the current status quo. They could either be well-designed or ill-designed. So back 50 years ago, for example, cars had to have 3 mirrors, a mirror on the left side, a mirror on the right side, and a rear view mirror in the middle. Well, we still have that requirement, in spite of the fact that we have cameras nowadays, video cameras, that do a lot better job in some ways than all those mirrors. Bicarbonates are a better material to use than glass in windshields. Well, cars still have to use glass because it's part of the 50-year-old standard. So you can see how even a civil law that's informed by the status quo, when it's put in place, gradually, that's well informed by the status quo, gradually gets out of touch thanks to advancing technology. And then uninformed, or what I call these laws that are ill-designed, and that's like the federal motor vehicle safety standards today, they're way out of date. And then ill-informed ones are ones that just don't reflect the common good at all. They are driven by special interest groups or lobbies. And these all have these, public choice concerns and unintended consequences. This shows how civil law has supplanted common law in 2 ways over the last century. And this is a huge thing that people just are not aware of. They don't realize that as recently as a century ago, we were primarily a common law country. Now we have much more law, but common law is just one small part of it. And there are 2 factors here. One is as legislation imposes on more and more formerly private matters, and as regulatory and criminal enforcement has mushroomed. Here's another example of how common law is gradually being eaten away at by civil law. The central Chinese government's taking over of Hong Kong, which for over a century was governed by British common law. And just earlier this month in The Economist, it talked about how 2 British judges who brought common law sensibilities to Hong Kong quit the top court because with things being imposed from the top down, they didn't feel like they could honestly be part of that new legal regime. Okay, so that's all I'm going to say about common law and civil law for the moment. let me turn to this exploration, exploitation, optimization model. So this model is widely used throughout the social sciences, so corporate strategy, artificial intelligence, game theory, you name it. Widely used. It's a very simple, widely applicable model. It's basically just a learning model. An animal is foraging for food. Animals don't forage for food anywhere, just anywhere. They look around for the food. They find a place where there's plenty of food, and they hang out there and eat that food so they can survive. We don't drill for oil or gas just anywhere. We do research and sonar and so forth, try to figure out where the oil and gas are, and then we make the big investment of scaling up and drilling the hole. That's the exploitation. So there's exploration followed by exploitation. We don't just willy-nilly invest tens of millions of dollars to make a highly automated manufacturing plant before doing market research to ensure that there's going to be a good fit between product requirements, customer requirements, and the product. Again, exploration, exploitation. And finally, we don't just invest willy-nilly in stocks. We analyze which ones have performed well, decide which ones we think are going to continue to perform well, and do our portfolio management that way. So the goal is to optimize something in each case, either survival or revenue or prediction accuracy or profit. The exploration and learning informs the exploitation and standardization and scaling up. And there's no single optimal trade-off in real-world cases. What percentage of my budget should I spend on exploration versus exploitation? There's no one right answer, and it depends upon the technology and also the environment. Now, what does that model tell us? Well, one of the things it tells us is if the landscape is shifting, more exploration is needed. Think about it. If you're that animal foraging for food and the climate is changing and new competitors, who might compete for the same food are coming in, or new animals that might prey on you are coming in, you constantly have to be shifting where you're going to live. Think of this as a landscape that's moving up and down. So the more this is shifting, the more exploration is needed. Obviously, if it shifts and we don't explore, we just stay in one place, we're likely to starve to death. If for a stable landscape, more exploitation is possible. So for a stable landscape, we don't have to do as much exploration. Makes sense. What else does the model tell us? Well, if the terrain is changing continuously, then we need continuous exploration. If it's changing continuously and we limit the amount of time we do the exploration, at some point that exploration is going to come out of date, and we're not going to have any, it's going to be like that 50-year-old highway safety regulation. And if for all of these factors, more exploration is optimal. If there's more environmental or societal uncertainty, if it's a broader territorial expanse and regulation and variation, or the payoffs take longer, then more exploration is optimal. Okay. Now, what are the implications of this for common and civil law? Well, for more dynamic economies and societies, more civil common law is needed. And our economy is, in some ways, becoming more dynamic every year, because innovation can happen at a ever faster pace every year, as one idea can piggyback off of another more readily thanks to high-speed search, high-speed communications, high-speed transport. It's easier for people to get together, exchange ideas, and that gives rise to innovation. So that would suggest that alone, the inexorable increasing pace of innovation would suggest we should be using more common law rather than less. For more stable economies and societies, more civil law is possible. If it's continuously changing, we need to retain some amount of common law indefinitely to inform what our regulations should be. With more uncertainty, broader territorial expanse and variation, longer time horizons, more common law is in the mix is optimal. And this is one of the references I cite in the paper. When an environment is sufficiently homogeneous and static, statute law is superior, but when more heterogeneous and dynamic, case law is superior. Well, here's a hypothesis I'd like to put forward, and that is civil law and declining economic dynamism reinforce each other. What do I mean by economic dynamism? That's the magnitude of change in an economy encompassing new business formation, frequency of labor market turnover, geographic mobility of the workforce. So the more I have civil law, the more that reduces dynamism, because it forces things to be a certain way. It makes innovation harder. I talk about how civil law is what I broadly call imposed regulation, makes innovation and entrepreneurship harder. And since there's less dynamism in the economy, it invites more civil law, and more civil law then makes the society more dynamic, and you can see this becoming a negative feedback loop, gradually becoming a more and more statist environment. So what are conclusions? As the pace of technology rises, we should be using more, not less, common law, but just the opposite is happening. 2, public choice and other factors incentivize governments to apply statutes to former common law domains. And so we need to constantly remind and re-educate political leaders, business leaders, educators, journalists, everybody on the essential role of common law, and to use restraint in coming up with new regulations, which is the first thing anyone thinks about when there's a problem, not resolving things in the courts and letting solutions emerge. So, in short, no civil law without common law. So, there you have it. Thanks for having me. Now, I really am depending on your comments and questions, because this is only the second time I've given this talk. And the first time I got lots of good feedback, which I used to refine this. And I have a feeling from this gentleman right here, I'm going to get even more good feedback.
You're very yeah. So I have a question, because you just mentioned Taylor and this idea of anti-fragile.
Yes.
And then I remembered this book by Bruno Leoni, which is called Liberty and the Law.
Yes, I cite Bruno Leoni, believe it or not, in my book.
Oh, really?
On entrepreneurship, if you can believe it.
Well,
yeah, I'll show you. Go ahead. Keep going.
He writes about this idea of legal security, and he says that in a sense, civil law is more secure, because it's a black and white text when you can read it, and it has a clear, hopefully a clear messages.
Yes.
But on the other hand, you can change the civil law with the whim of a politician. So in the long run, it is not that secure.
Yes.
Whereas the common law perhaps is more difficult to understand or to interpret, or you need a judge to do this job, but it doesn't change according to the political bias of the time. So in this sense, he says that it's more secure.
It's harder, common law or civil law?
Common law. Yeah, common law is more secure.
It's harder to corrupt.
Yeah.
Because there are so many control points. Should you be in front of the screen so people can see? Okay. So, yeah, I actually mentioned that point in the paper, but I forgot to mention it in this PowerPoint, which is I don't want to say incorruptibility of common law, but that it's much harder to corrupt, because who do you go to bribe? Do you bribe, 10,000 judges across the country? That's going to be tough. But as long as there's one central control point, like a parliament, like a Congress, like a chief executive, then that's very susceptible to bribery. Yes.
Thank you. I just wanted to ask your opinion on a specific case, actually, that happened recently in America.
Yes.
I'm a nurse, and you might have seen recently there was a nurse who, in America, she gave the wrong drug to a patient, and she has been charged with murder. And I think under common law, this sets a precedent, which is worrying for nurses. But my question really is, the situation there was a nurse against a hospital which has billions of dollars behind them. And I think that situation is happening more and more. So can common law still be considered to be just or fair in that situation where one party has a lot more power?
Well, if I were a judge, the first thing I would do is look through previous cases and see how they were resolved, and try to find cases that were as close as possible to the circumstances of this case. And a judge isn't compelled to follow precedent. And in fact, stare decisis, let the circumstances stand, let the previous decision stand. That's a relatively new development in common law, with the printing press. I know this shows you how long my time horizon is by saying that the printing press is a relatively new development. But before the printing press, people couldn't even write down the precedents. It was more based on memory, and so it was more. There was less stare decisis, less harking to precedent, and more each and every case, the judge made a decision about, okay, what's the most reasonable resolution in this case. So, and what was a jury involved in that case? Did the jury?
I'm not sure.
Because I don't know anything about the case other than what you've just told me. The circumstances was, I would think that factors that would come into play would be how meticulous and attentive was the nurse, and what is her history, and how easily could a human have made the mistake of administering the wrong drug. Was it understandable, or was it not reasonable? Was she drunk? Was she was she up late the night before, and so not operating at 100%?
But all of that, you could argue manslaughter, but to argue murder is like a premeditated thing. So I think that's the worry with that particular case.
So again, how did they arrive at a first or second degree murder case? Was it it must have been. Did they feel like it was intentional? She didn't like the patient?
I don't know, but I think all of us as nurses who've been following this, nobody understands how they arrived at that conclusion, yes. And that's why it's worrying for anybody who makes a mistake.
Yes.
I think, yeah.
One of the things I talk about in the paper, again, in the interest of time, I didn't include everything here, is how judges, with the intrusion of statutes, have less and less freedom and agency. Yeah. And so if there's a regulation or law that applies exactly to this case, it's going to be hard for them to hark to previous cases.
Yeah.
And they probably pretty much have to go with whatever the law or the regulation is. If the law or the regulation doesn't go precisely to the case, then they may have some leeway. And so they're being squeezed into a smaller and smaller space of using their own judgment, and that means that these regulations that have been drafted for, say, the entire United States, one size doesn't necessarily fit all.
No.
I mean, the customs and practices in the Southeast might be very different from in the Northwest.
Yeah.
Anyway, those are a few thoughts.
Thank you.
Hi. How are you? Yes. My name is Tomas.
Tomas.
I'm studying right now the administrative state discussion in the United States in my doctoral thesis. So it has been very amazing to see how not only let's say the regulatory environment in the United States changed after the Great Depression,
Yes.
but also the whole legal, let's say, mentality with the administrative state created by this vast amount of agencies, which we're not even sure how many there are at this very moment.
Yes.
Not only on the federal level, but also on the state level, and even on the local level as well. So, but what has amazed me is that liberal thinkers, at least contemporary legal thinkers, let's say Hayek, Mises and stuff, Hayek was more explicit about banning, as you say, or trying to impede civil law interferes with the common law mentality of judges and lawyers in the whole American system. But for instance, Ludwig von Mises, a very well-known theorist on the liberal ground, was a legal positivist, and in a way he was befriended or even a family member, like a not very close, with Hans Kelsen, the Austrian positivist thinker. The lead positivist thinker.
What was Hans's last name again?
Hans Kelsen.
Kelsen,
yes.
How do you spell Kelsen?
Kelsen.
Okay, I'm not familiar with him, but I want to.
Yeah, it's like the father of European legal positivism.
Okay.
But this is very curious. I mean, America not only changed its regulations, but it changed the whole mentality of judges, and even the Constitution has been rewritten. I mean, we have to cope, liberals. I mean, within the liberal family, we need to strive more for bringing this kind of subjects to liberalism as well. Not only seeing law as an impediment, let's say, to economic growth and economic development, but also just the whole legal mentality, because judges think differently now. Administrators think differently now.
Yes.
I mean, so we don't see the point of how this has changed so much the legal mentality of lawyers, judges, and administrators.
You know, I am so thrilled to be in an audience where people already realize that chart that talked about how profoundly things have changed in the last century, the two pie charts, that is invisible to most people. But you folks are aware of that, and you in particular, sir, are aware of it. You know, I would love it if you would email me whatever references you think would be most relevant here, because I'm really interested in this topic, and I'm looking for the best additional papers to read on it. I'm John at johnchisholmventures.com. Thanks. Thank you, sir.
Hello.
Hi.
I really enjoyed your speech, it's very interesting. I will ask you, as a lawyer, I do use civil law in many countries in Africa and South America, and one of the main problems I see is that the more complex and the more laws, text laws are approved and applied, there's, even if the legislator doesn't want to, there's more and more contradictions, logic contradictions in text.
Yes.
Okay,
Yes.
so for example, in Spain, the constitution in Spain, private property is protected above all, but there's an exception, and that is the necessity of the public necessity. Okay, so yeah, the common good, the emergencies, you know, but so the problem goes, what is public, the common good, the public necessity. So we need another text and another and another. So yeah, so civil law keeps growing and growing and growing. That's crazy, because you can't you can't take a case and say, okay, you can resolve this using this law and this one. No, it's more and more. It's getting more and more difficult, but I think that principles, okay, must be applied. So the problem with common law, what are those principles? I mean, there's cases, okay, you discover the law, the rules that rule the society, but what are the origins of the principles? What's the first case, the first judge, what principles he had to use? That is I will say that's the main flaw with the common law.
Well,
I wouldn't call it a flaw, but a thing that must be explained. And
so again, it's the reasonable person test. What would a reasonable person in this society consider most reasonable? And so the judge's law is the judge's job, it seems to me, is to discover that. Maybe the judge has to do some research, talk to people, try to make a sense for what would a reasonable person in this jurisdiction consider most reasonable. And in fact, Bruno Leone talks about this. He says the purpose of the law is the law. Actually, I have the quote in my book on entrepreneurship. It's something like the purpose of the law is to discover what's right. I don't want to take time right now to find this. You know what would be great? Let's circulate, if you guys are willing, a sheet of paper with your email addresses on it, and I'll send all of you a PDF of that article, and then I'd welcome anyone volunteering other references that are relevant to this subject, and because I'm just eagerly eating up everything I can find on it. So, and you guys are knowledgeable and passionate about this, or else you wouldn't be here. So I want to learn from you.
Hi.
Hi.
Hi, thank you so much for your talk. It was really interesting.
Thank you.
I was wondering what implications do you think your thesis has on the management, specifically the socioeconomic management of COVID, of the recent pandemic that we just gone through? Right now, I'm a doctoral student. Actually, I just overheard that you were in Cambridge. I'm there, so I hope you had a nice welcome.
Cambridge, Massachusetts?
Oh, I thought, no, Cambridge University in the UK. Like, you know, the Cambridge Union usually invites speakers like you, like politicians and entrepreneurs, and I thought you were a guest, a recent guest.
I was.
Of the
actually.
Cambridge Union.
I was at the University of Cambridge in the UK.
Yeah.
And there's a video on johnchisholmventures.com, front and center, of a talk I gave not on this subject, but on Unleash Your Inner Company.
Oh, okay, great. You just to wish that you had a nice welcome there. I haven't been there in a year. I'm doing my doctoral field work here in Madrid at the moment.
Okay.
And I'm a social anthropologist, and I've been doing field work with one of the many solidarity networks that popped up in one of Madrid's socio-economically low neighborhoods, Vallecas. And I've been sort of unearthing how the response from neighbors, it's basically a network of neighbors that collect donations in kind and in cash from private donors, from supermarkets, from companies, and then redistribute it in baskets to the neighbors that need it the most. So it's kind of like a self-managed network of self-provisioning for the COVID emergency. And I've been finding that although they have a lot of conflicts and warts and all, it's a messy picture, but overall they've been systematically outperforming the social services, the public administration, when it comes to outreach, when it comes to knowing what the community needs.
Yes.
When do they need it, how do they need it.
Yes.
So to the point that even social services were referring people back to the informal neighborhood network.
Civil society based.
Yeah, it's
Yes.
purely civil society. It's a bunch of neighbors from this socially working class neighborhood that just started collecting. At the beginning it started with people doing grocery shoppings for those that were very old or immunodepressed, or people who were vulnerable to leave their house in the first wave of the pandemic during lockdown. And then it just developed to this kind of network of supply of delivering food to thousands of neighbors. Is one of the largest neighborhoods in Madrid, actually one of the biggest ones in Europe, I think. So in my findings, I've seen that knowing the supermarkets of your neighborhood, knowing the people in your neighborhood, knowing the people in your block actually allows you to should that be your wish, to provide help for them more effectively than social services ever could. Because by the time that they knew what was going on in social services, people were already receiving baskets from these people, and they were already being helped by their fellow neighborhood neighbors. So my question is, what kind of balance do you think could be stricken between, it's not exactly civil law and common law, but it's kind of like bottom-up regulation or management of the crisis, and versus top-down. Maybe like that there could be a concession in this room. I don't think, maybe perhaps that there could be a concession that there should be some nationwide or statewide strategy for like the bigger picture of how to contain this disease in the first place. But when it comes to social welfare, I think non-state alternatives are much more effective and much more powerful, and tend to optimize resources a lot better in general. This is a very convoluted way to try to ask what are your thoughts on this thesis, but kind of like extrapolated or applied to the socioeconomic management of COVID-19.
Nowhere in the COVID pandemic did we ever hear President Biden, President Trump, Dr. Fauci, whoever, nowhere did we ever hear them say, use your own good judgment. If you are 65 or older, if you have medical conditions, don't go out, or wear a mask. If you feel confident in your personal health, take the liberty of continuing your day-to-day activities, so we can keep our society going and economy as much as possible. Nowhere did we hear a leader say, use your own good judgment. And that's what we needed to hear, and I wish we had heard. I mean, ultimately, people are going to use their judgment anyway. And if you force them to do something against their good judgment, then you're going to get a bifurcation or polarization, and indeed, that's what we've gotten. Anyway, those are some thoughts. You know, I'm deeply concerned that people here are going to start leaving before we have their email addresses, your email addresses.
Don't worry, don't worry.
So
We'll give it to you.
would some, or do you already have the email addresses of everyone who signed up or not?
No, we will gather it, don't worry.
Okay, or should we circulate a sheet of paper?
Yes.
Okay,
No problem.
let's do it.
I will do it right now.
Thank you.
Okay, so do we have another question? Yep.
Hi, Jackie.
Hi.
Jackie, I forgot to tell you that Jackie is my sister's name.
There you go.
Yeah.
So super interesting, and in brevity, I'm not going to go into all the questions that I think this raises, but I think it's obvious with the negative feedback loop, if you want, it's not just the law itself, it's the enforcement of that law. So to your point, with all of these unelected agencies that we have in the US, they have veritable armies, right? Or enforcement parts of the agencies. But my question really is, where is the focal point to be able to start to turn this around? Because the incentives as they are, it would appear, is just like with regulation, an overwhelming abominance of civil codified, recent untested law benefits the people in power who make it and who enforce it, and generally, and the long-term big players in the case of regulation. So if the people that are making it and enforcing it are the ones who are benefiting from it, other than great social upheaval, what do you think would be 1, 2, 3, the most important area to begin to turn this around and resolve it?
Well, my objective is modest, and that is just to make people aware of a different approach than we're currently using. I mean, the first thing we all naturally think of is, if there's a problem, okay, how can we introduce a law or regulation to address the problem? It's the first thing we think of. It's visible, it's tangible. Letting courts of law find good resolutions is not very visible. The fact, the extent to which we've strayed away from having courts of law find the best resolutions for conflicts is not visible to anyone, hardly, except for this gentleman back here and the rest of you in the room. So I'm just trying to, that's a first step, is to show what other approaches are possible. Here's a good question to think about. How much does the U.S. spend on regulatory agencies today? Billions, tens of billions, maybe, I guess probably not trillions, but certainly hundreds of billions. How much do we spend on our court system? I have a hunch it's much, much less. I don't know what the ratio is. If anyone knows, that would be really useful data. And the regulatory system has mushroomed while our court system has languished in terms of funding, and it's gotten outdated, and the length of time it takes for a case to be heard and resolved just extends longer and longer. It's become less and less efficient. We've neglected that. And yet, efficiently and rapidly resolving cases, disputes between people, I can't think of anything more fundamental for a government to do. I mean, an anarchist may think it's not a proper function of a government, but anyone who believes in minimal government, no matter how minimal, thinks that having a system of courts to resolve disputes between people is going to be part of that government. And yet that's the part we've let languish. And what if we took just 10% of the money, the funds that we spend on regulation, and shifted it to the court system to make it more efficient and more visible and sought after as a way of resolving a dispute? I think it would be worth a shot to see if people find that persuasive, to shift some of the funding that we're spending on regulation to court cases, to courts of law. What do you guys think? You tell me. You're an attorney, as I understand it, sir. Is that correct?
Yes.
Okay.
The reason why the government doesn't want to do that, at least in Spain, or you can list many of them. I would say that one of them is just control.
Yes. Repeat that again through the microphone so our audience in the Zoom can hear it.
The government doesn't want to do that. I mean, the fact that the legislator can just modulate the society at his wish is a very, very important power that he doesn't want to give it to a judge that can't be controlled, etc. So
right.
I don't think that's going never happen. I mean, it's from my point of view, what I see is like totally the opposite. In every country, South America is civil law. Africa, for example, it's very interesting because I work with Senegal, Angola, Cameroon. It's like French civil codes, but they are very, very small. So they have space for liberty. But it's getting bigger and bigger.
They have space for what?
For liberty, for
yes.
private transactions. I don't think that the world is going to more liberty. It's getting more civil, more.
I think what he's trying to say is that politicians don't want to give up this power they have with the common law.
Yes.
Whereas, actually, in Spain, one thing that is happening is that especially the left-wing parties, we have kind of like 2 or 3, they say that even our country uses the civil law. They say that still, as the judge has to sometimes make an interpretation of the law, but they are fascists. They come from the dictatorship. No, we've been hearing this. So they don't apply it in the way the law is meant to be applied.
They're referring to the judges.
The judges because they come from this tradition from the dictatorship. So they now are saying, for example, that current judges have to be trained and taught how to apply the new law. You see?
Yes.
So that's the one thing I wanted is very quick. Have you done some research regarding because we see that the common law is quite flexible, right? It adapts kind of like easily to the changes in society and the economy
and technology.
But so this should be good for entrepreneurs, right?
Yes, for sure.
But at the same time, investors, kind of, let me be a bit of a devil's advocate. Investors usually try to find very stable regulatory fields to invest their money on. So do you think that maybe common law is very good for, entrepreneurs, etc., and at the same time, civil law countries are very good for,
in general investors?
So if I understand your question correctly, is it the case that common law is better for entrepreneurs and civil law is better for investors? Is that correct? Well,
it's an intuition, that I have.
So again, they do have pros and cons. Let's see if I can bring that back. I think ultimately common law is better for both investors and entrepreneurs. Because, I mean, look, the US is more common law oriented than just about any country in Europe, maybe any country in Europe. The one I'm not sure about is the UK. Which is more common law oriented, the US or the UK?
It should be the UK, but I'm not sure. Probably not.
I'm not.
After years of being in the European Union, probably,
Yeah. So that's a good question and a fun question. But either way, certainly the U.S. is a more attractive, has attracted more capital, especially more venture capital for innovation and entrepreneurship than Europe has. And I think where common law is good or attractive, who it's attractive to, is not so much investors, but established players. Like, take the pharmaceutical industry. Pharmaceutical have high barriers to entry. The cost of clinical trials nowadays might be $1 billion for a new drug. That's a huge amount of investment for a startup company. And almost certainly a startup is the outcome for a successful startup in pharmaceuticals is to be acquired by another existing pharmaceutical company. And so the pharmaceutical companies, the handful of them, the 8 or 10 major ones that represent, I'm guessing 80 or 90% of the pharmaceutical industry in the US, they don't have to worry too much about competition, new competitors coming along, because they know how expensive it is going to be. They just want to make sure that if a new pharmaceutical firm comes along, it's an acquisition candidate for them. So a heavily regulated industry is attractive to the entrenched players, and indeed the entrenched players will encourage more regulation. Look at Facebook. Facebook posts ads all the time about how we need 21st century regulations for social media. That doesn't help the entrepreneurs. Look at the European data regulations, how expensive that is to comply with. That's got to be hurting new software companies in Europe. But who welcomes it? The well-established players like SAP, Salesforce, Facebook, Microsoft. So, yeah.
Okay, we have a question from our YouTube channel. Ulises asks, can new technologies and more precisely smart contracts make the rules without rulers principle possible?
Hold on, because Tomás will make first another question and you will answer those questions together.
So, just one comment. I would say, you think the U.S. Constitution would be like a good model for common law? I think so. Why do I think so? Because it imposes a limit on legislation. What I feel with the administrative state and what has happened in the last 70 years or so is that, the route, let's say, has deterred to an administrative state I mean, you have concentration of powers on every one of those agencies. You have prerogative, like royal prerogative is back again. Each of those agencies has not only regulatory powers, but enforcement powers, and they also they have like pseudo judicial powers as well.
Yes.
So the model of the Constitution, the written Constitution, is a good one for common law. I mean, it was a government that has like a good, let's say, partnership among businessmen and the officers, let's say. Now we have a different model.
I hear you.
I mean, the original Constitution should be like restored.
So there are two very different questions here. The first one dealing with Ethereum and automated contracts, and the second one dealing with the Constitution. I don't know to what extent the rules, the business rules that are built into contracts are different than the rules that could be built into a non-automated, I mean, a paper-based contract, but just has checkpoints that people review, you know, milestones and such. And I'm not sure that automating the process changes anything. It just makes it easier, more efficient, and so forth to do it. My guess is that the contract probably has to comply with the law and have a clause in there, you know, that this contract is, or agreement is under the laws of the state of Delaware or California or whatever in the U.S. I presume there's a counterpart to that paragraph in an automated contract. Maybe one of our legal experts here could weigh in on that. So that's all I can think of to say about that, but maybe someone else can offer some thoughts on that. I find it interesting regarding the Constitution that the Bill of Rights, as I understand it, was at first controversial, that people questioned whether we needed it. And there was one school of thought among the founders was it sort of messed up the Constitution, which was, you know, concise and so forth, to have the Bill of Rights here. Well, as I understand it, for the first 150 years of Supreme Court cases, they didn't generally hang on the Bill of Rights. But now, I understand, most Supreme Court cases hang on the Bill of Rights. So by golly, it's a good thing that we had it. And those people who were concerned that it was both belt and suspenders to have a Bill of Rights were wrong. We really did need the extra suspenders in the Bill of Rights. If we could make any changes to the Constitution today, what would they be? Well, I think a wonderful aspect of the U.S. Constitution is the separation of church and state. And that separation, I wish we had made or could have made for many other things as well. For example, what if the U.S. Constitution also said there will be separation of church, of education and state, or of economy and state? Just those additional concepts in the Constitution, I think, would have made a big difference and a positive difference.
Okay, John, thank you very much. It's been a very illuminating speech. Thank you so much for being here at the UFM and Instituto Juan de Mariana. A vosotros muchísimas gracias por acompañarnos, a todos los que habéis venido aquí y habéis hecho todas estas preguntas. Y la semana que viene tenemos una nueva conferencia, La Ley Trans a Debate, nada menos, con Lucía Echevarría y Gloria Rodríguez, así que os esperamos a todos. Muchas gracias.
Thank you.
Thank you.